I always apologize about that because it's always really loud when
It's all
we're
right.
recording. Good morning, everybody. Thank you all so much for joining us today for our Advocacy Cafe with Edna Sprague and New Mexico Legal Aid. As you all know, there has been a lot of evictions with COVID-19 and the protections and ongoing changes with the Supreme Court. And New Mexico's also, their protections here specifically for New Mexicans, and also how survivors are being affected with these evictions and everything that is happening within our state. And so we felt that this was an important topic to talk about during Advocacy Cafe. And so with that being said, this is a webinar. Go ahead and insert your name and your chat in the chat, any questions that you all have, any concerns that you may have, anything at all, please interact with us during the session through the chat. We are also live on Facebook as well. So those of you that are coming across our Facebook Live, please also take this opportunity. If you have any questions, would like to know something, please interact with us on Facebook. There will be a certificate given for those that are attending the webinar for our advocates across the state of New Mexico. There will be a survey that will be sent to you at the end of the webinar. So please keep an eye out on that. As soon as you complete the survey, you will attain your certificate. So that's something that we have been working on here at the coalition. So where you don't have to wait for the certificate, as soon as you complete the survey, you attain the certificate. And so feel free to use the chat right now if you would like to introduce yourselves. But with that being said, I'm going to turn it over to Edna. Thank you so much, Edna, for taking the time to do this training for us here for New Mexico.
Thank you. I'm really excited to be here. For some reason, I'm not able to see the chat, Teresa. So if you see something, questions, please feel free to interrupt me, and I'm happy to answer questions as I go. This PowerPoint isn't extremely long, so I don't anticipate taking up the entire time. So I'm fine having just a kind of an open call for questions and any burning issues that people have, or thoughts, or anything along those lines. So good morning, my name is Edna Sprague. I'm the litigation director at New Mexico Legal Aid. As a caveat, I have to say that my specialty is not housing. My specialty is litigation, doing helping victims obtain domestic violence orders of protection and related family law. So I have to give credit to our housing practice group manager. His name is Tom Prettyman. Some of you may have seen letters to the editor and such that he has been writing really since the pandemic hit. And Tom really was a great help in putting this training together with me. So I like to think that he's the brains and I'm the mouthpiece, because I'm pretty good at that. So any errors in this presentation are mine. If anything I say does not seem true or accurate, please feel free to call me out on that, and I will try and get corrected information or double check everything that I'm saying with Tom. So with that, I will go ahead and get started. So, I have to say that when I actually first started at New Mexico Legal Aid about 20 years ago, I did housing, and I found housing to be incredibly depressing, mainly because housing law is very landlord friendly, and we don't have a lot of resources. Pre-COVID, we didn't have a lot of resources for people in poverty facing eviction. And I found that incredibly depressing. I gravitated towards domestic violence because while seemingly the subject matter is potentially more gruesome, the resources available to victims who are homeless are much better. They're not great, but they're much better than poor people. However, with the kind of blossoming implies something good, but with the blossoming of COVID-19 back in March of 2020, we really started to see more resources for people in poverty facing eviction, and generally anybody who was facing poverty. And the interesting thing is that we at Legal Aid realized that there were suddenly a whole new population of people who were newly poor. So people who had worked and had always had relatively successful, gainful employment, we're suddenly out of work and we're facing unemployment barriers, benefits barriers like food stamps, et cetera, and housing barriers in numbers that obviously we had never seen before. And the interesting thing about this new population of people was that these were people who had never really intersected with the court system in ways that people who are traditionally and historically and continually marginalized do. So poor people face constant eviction, and you might encounter some clients who have just a history of eviction after eviction after eviction. And so COVID expanded that population and introduced a whole new level of people who had never been people who faced housing insecurity. And that coupled with, I think, new issues, that being a new issue with domestic violence survivors, also kind of compounded the problem. So hopefully we'll provide you some clarity on these issues. So I just want to start with some basic definitions. So first of all, landlord-tenant laws are governed by the Uniform Owner-Resident Relations Act and the Mobile Home Park Act. And both of those are New Mexico laws. And there's a little bit of a variance in mobile home park evictions because those can involve people who own a mobile home but are renting the space. And so they're a little bit different in terms of the laws, but generally, when we're talking standard eviction, so landlord owns an apartment or a house and they are seeking to evict a tenant, they have to file what's called a petition for a writ of restitution. And those cases always proceed in magistrate court and metropolitan court. So not district court where domestic violence orders of protection and most felony cases, criminal cases reside, is in district court. And one thing that's interesting about magistrate court is that the courts do not routinely record landlord-tenant eviction housing cases. So that can make for a challenge if any attorney appeals any issue out of landlord-tenant land, out of magistrate court. So if you're dealing with a client, a victim who is unable to obtain counsel, but is going to represent themselves, you want to make sure that that client knows to ask the court to record the proceeding. They can request that the proceeding be recorded. And forms for that request can be found online at nmcourts.gov. So petition for writ of restitution is the landlord asking the court to evict the tenant. And there are a couple of different ways in which this comes about. The most well-known or most obvious, obviously, is an eviction for a non-payment of rent. And the way that that goes is that the landlord has to serve the tenant with a notice that the tenant has not paid rent, and they have to give the tenant 3 days to cure that non-payment of rent. And if the tenant does not cure that non-payment of rent, then the landlord can file a petition for a writ of restitution. And there are lots of sort of technicalities inherent in that. The notice has to be done certain ways, but a tenant is given the opportunity to cure that non-payment. Other ways that that landlords can seek writs of restitution is if the tenant has violated the lease agreement. So for example, using drugs on the property, non-payment is a violation of the rental agreement, obviously. Fight with a neighbor, domestic violence incident occurring, having an unauthorized person living with you. So, your brother and your mother and your cousin and your auntie all come to stay with you and they're not authorized on the lease. A huge, drug bust, for example, police raiding your apartment, those are violations of a lease agreement. There are two types of violations of lease agreements. There are 3-day notices and there are 7-day notices. And 3-day notices are notice of substantial violation. So if there's a domestic violence incident where the victim is shot and injured severely, that would be a substantial violation of the lease agreement. And the lease agreement typically would say something like, not engage in criminal activity. And where legal aid comes in is in representing if a petition of writ of restitution gets filed against a domestic violence victim who was the victim of that shooting, we would defend her in court from that eviction proceeding. And I'll talk about that in a second. And what happens is the writ of restitution, the petition for writ of restitution, is a summons to court. And so the tenant needs to go to court and appear in court. And the court takes evidence from the landlord and takes evidence from the tenant. And the court decides whether or not they're going to grant the landlord's request for a writ of restitution. The writ of restitution is the document that is issued by the court after an evidentiary hearing on the petition, and that writ authorizes the sheriff's department to remove, the tenant from the rental. Now, every judge can give tenants up to 7 days to vacate the premises, but depending on how interested the landlord is in having the tenant vacate the premises, I believe that those writs can be as short as within 24 hours. And what happens is the landlord takes the writ of restitution, gives it to the sheriff's department, and the sheriff then assists the landlord in executing that writ. Many tenants move out before that occurs, but not everybody. And so literally what will happen is the landlord will show up on your doorstep, tell you to get out. They might or might not give you a few moments to gather your items, and then the landlord comes, changes the locks, and your stuff is lost, essentially, unless you can make other arrangements with the landlord. So we've heard about the New Mexico or we've heard about eviction moratoriums, and there I want to talk first about the New Mexico eviction stay. So a moratorium is an absolute prohibition on any kind of eviction, on evictions. And New Mexico does not have a moratorium on evictions. The New Mexico Supreme Court calls it a moratorium. The press calls it a moratorium, but it is not a moratorium. It is a stay. And it's based on 2 orders issued by the New Mexico Supreme Court in 2020, and it only stayed evictions for an inability to pay rent. Okay, so it does not stay evictions if for substantial violations or just standard violations of a lease agreement, and it does not stay evictions if a tenant has overstayed their lease. So for example, I have a month-to-month lease. The landlord gives me a 30-day notice to quit. I do not move out after the 30 days. I pay, let's say I try to pay rent. The landlord does not accept my rent and goes to court and asks that I be removed from the apartment for violating the expiration of the lease. That is not an eviction, that is stayed. So the court is still issuing evictions, writs of restitution for other violations of lease agreements other than inability to pay. And they are not staying the hearing on the writ of restitution. They are only staying the execution of the writs. So let me say that again. If your clients get served with a eviction, a petition for writ of restitution alleging that the tenant has not paid rent for 3 months, the client still has to go to court and tell the court why they were unable to pay. And they have to be able to prove their inability to pay. And I'll talk about how one does that. But they have to be able to prove it. And the court can still say, I am evicting you for non-payment of rent. And the court can still issue the writ of restitution, which is an order directing you to be removed from the premises. But what they have stayed is the execution of those writs. So what that means is that the landlord cannot take that writ of restitution to the sheriff's department and ask the sheriff's department to remove you. Now, that's what the law says, but not every sheriff's office is abiding by the stay. So some landlords across the state are still taking those writs when the court gives it to them and giving it to the sheriff and asking the sheriff to evict tenants. So tenants are still being evicted for non-payment of rent, even though they've been able to show that they could not pay rent during this time period. So it is irrelevant to the court if the inability to pay rent is directly tied to COVID. So what that means is that the client really has to show that they, for whatever reason, have been unable to pay rent during this time. Obviously, their case is going to be stronger if they can show that their inability to pay rent was because they got laid off from COVID. And the way that the client would show that would be to show their bank account for the last couple of months or testify about how they have not had any income coming in. They're receiving, let's say food stamps or something along those lines. So housing cases are still happening. It's just that the execution of the writs is stayed or is supposed to be stayed. Bernalillo County is pretty good about it. Doña Ana County, all of those jurisdictions the larger jurisdictions have been good about it. So we've heard about the moratorium that was an actual moratorium that was issued by the CDC. And that moratorium was struck down by the Supreme Court of the United States in September of 2021. So that's no longer applicable. But the CARES Act, which was passed in, I think, July of 2020, did create some protections. And what the CARES Act, the only protection that it extended for housing, was it required a 30-day notice of non-payment of rent to eviction for certain types of properties. So in New Mexico, under the Uniform Owner Resident Relations Act, it says that a landlord only needs to give a 3-day notice of non-payment of rent. The CARES Act says, no, that notice now has to be 30 days. And so it gives the client a little bit, and by 30 days, meaning it gives the client 30 days to cure that non-payment issue. But it only applies to certain types of housing. So public housing, HUD, USDA, Section 8 tax credit properties, and property with a federally backed mortgage. So let's say that mom and pop landlord got a Fannie Mae loan to purchase their house. That is a federally backed mortgage of a rental property wherein the CARES Act protections would apply. Are there any questions about the moratoriums or stays? So New Mexico probably provides more protection than, well, certainly the CDC moratorium is gone. And so New Mexico does provide more protection under the CARES Act than the CARES Act, although the CARES Act extends the time in which a tenant has to cure non-payment of rent. So let's talk specifically about domestic violence protections. Now, the federal law is broader in some ways and narrower in some ways than New Mexico. Oh, and let me just go back. Let me back up real quick. The New Mexico eviction stay applies to all cases under the Uniform Owner Resident Relations Act and all cases under the Mobile Home Park Act. So federal domestic violence protections. So VAWA, the Violence Against Women Act, applies to most federally subsidized and tax credit properties, but not Indian Housing Services or authorities. So again, federally subsidized is Section 8, housing authorities, subsidized housing, low income tax properties, and a landlord who has a federally backed mortgage. Where an alleged violation of the rental agreement is directly related to domestic violence, acts of domestic violence, the judge cannot evict the victim, period. Okay. So the requirements to prove that it's domestic violence is that, unlike New Mexico law, so New Mexico law requires that a domestic violence victim get a domestic violence order of protection. Federal law does not require that. Federal law requires that the victim provide so the victim can say to the landlord, don't evict me, or a lawyer for legal aid could say, don't evict this client because of domestic violence. And the landlord can say to the victim, I need you to prove to me that that there was domestic violence, and the victim gets to select the way in which she proves that. Okay, so she can provide the domestic violence order of protection. She can provide a HUD, Department of Housing and Urban Development form that corresponds with the VAWA provisions. She can provide a police report, and she can provide a statement from a domestic violence provider agency countersigned by a tenant. So that means you guys who are providing services, obviously shelter services would not be able to do this because the client is with you rather than in her home, but you can provide a statement that you are providing services to a victim of domestic violence. She lives at this address and the domestic violence occurred on this date. And then the client would sign that, the tenant would sign that and present that to the landlord. So federal DV protections continued. So one neat thing about it is that it allows the landlord, it can require the landlord to transfer the tenant from one location to another location. So if the landlord has multiple apartment complexes, they can transfer the tenant to another apartment, or multiple apartments within one complex, they can move the tenant that way. The other neat thing is that it provides a confidentiality provision. So what that means is that information pertaining to the domestic violence is sealed within the tenant's tenant file within the landlord's business or record keeping. And so that means that the offender can't just go in if he's on the lease and ask for information pertaining to the domestic violence incident, because remember, it's going to potentially contain information about where a victim is being treated, for example. So there's a confidentiality provision that limits who can access that domestic violence information. It also requires landlords to provide provide tenants with information about what VAWA says and the HUD certification form that I was just talking about. So it requires landlords to do it at the application of a potential tenant at a property. It requires them to provide it at the signing of the lease, as well as with notice of termination of lease. So notice of termination of lease would be a notice of violation of the terms of the lease agreement. They're required to give that notice there. And, amazingly, a lot of landlords don't do that. And so one of the cool things is that we have been able to force landlords to comply with VAWA when we have received word that a tenant is being evicted because of domestic violence. And let me just say that domestic violence also includes, sexual assault or stalking, similar to what the Family Violence Protection Act says. Another cool thing is that, and we've done this, is if you have a victim who was evicted from a property 5 years ago, because of a domestic violence incident, but she was unable to secure representation and didn't know that an act of domestic violence was a defense to an eviction. And she goes in today to apply for an apartment, and the landlord sees that previous eviction on her record. We have been able, VAWA allows the current landlord, mandates that the current landlord overlook that negative rental history on her case lookup if she can show that that eviction was based on domestic violence. So we can rehab victims' tenant history in terms of evictions. We can't do away with the eviction. We can't remove it from her record, but we can ask landlords to disregard it. Are there any questions on the federal law? So state protections. So state domestic violence protections apply to more landlords. So it applies to all landlords, private landlords, housing authorities, landlords that purchased a home with cash outright and they're renting it. Doesn't matter how rich or poor the landlord is or who the landlord is, or if it's a housing authority, subsidized Section 8, low income tax, doesn't matter. It applies to all victims of domestic violence in their tenancy. But they have to have a domestic violence order of protection in order for the court to not have discretion on eviction. So what does that mean? So when you are a victim of domestic violence and you have been served with notice of a substantial or a non-substantial violation of a lease agreement, and the landlord is seeking a writ of restitution against you, a writ of eviction to have you evicted. If you do not have a domestic violence order of protection and you go to the landlord tenant hearing and you say to the judge, please don't evict me because I am a domestic violence victim, and the judge asks you if you have a domestic violence order of protection and you say no, the judge can still evict you. They can decide not to evict you if your testimony and your facts and your defense is very compelling, but they can still do it. If you have an order of protection, and it doesn't matter if it's a temporary order of protection or an extended order of protection, the judge does not have a choice. They cannot evict you. So the landlord may still very much want you out, but if you have a domestic violence order of protection, either temporary or extended, the judge cannot evict you. So where you raise domestic violence as the defense to eviction without a domestic violence order of protection, the court can still evict you. They can consider that evidence. And, you know, for the most part, we have success with this. I feel that I hear from our housing unit anecdotally that landlords are, like all people, have varying levels of sympathy and compassion for domestic violence victims. You know, some landlords don't care and want victims out. And so for those landlords who don't care and don't have any compassion, victims would be well advised to get a domestic violence order of protection. So New Mexico Legal Aid advises all domestic violence victims who are facing housing problems to get a domestic violence order of protection. So what that might look like is a potential client may call New Mexico Legal Aid and say, I was just served with a notice of substantial violation. We ask the applicant what is in the substantial, in the notice. And if the facts are, you know, on July 1st, tenant A, who is on the lease, John Doe, shot tenant B, Jane Doe, who is likewise on the lease, in the face. We don't want that kind of element around here. You need to leave. We are evicting both of you. and the victim has not obtained a domestic violence order of protection against John Doe, we will tell her that the way to stop the eviction against her is to go down and petition district court for a domestic violence order of protection. Now, interestingly enough, the landlord can still move to evict the offender, and the courts can and will do that. Now, a little quirk here is, and we run into this with some frequency, where the victim is not on the lease, and or not an owner of the home. And in that situation, we, as the domestic violence attorneys, would ultimately deal with possession of that property, the home, the apartment, through the domestic violence order of protection case. But if the victim has a domestic violence order of protection, the judge cannot evict her regardless of whether or not her name is on the lease. So even if her name is not on the lease, the landlord can still cannot evict her. And particularly if the family court domestic violence order of protection has given her possession of the apartment. So in domestic violence orders of protection, victims often will request not ownership, but possession of an apartment or a house, asking that the offender be removed from the property, and the magistrate or metropolitan court in the landlord tenant case are required to abide by that, both by law under the Uniform Owner Residence Relations Act, but also by law under the Family Violence Protection Act. And, I've had cases where I've had victims who were in a boyfriend-girlfriend relationship. They lived in the boyfriend's home. He commits an act of domestic violence against her. She goes down and gets a domestic violence order of protection and is granted possession of the home. He may go down to magistrate or metro court and try to evict her as a tenant. The courts, for the most part, are pretty good at realizing that that's what's happening. But if the victim has a domestic violence order of protection that grants her possession of the home, then that order trumps, no pun intended, trumps any proceeding in magistrate or metropolitan court. So the victim cannot be evicted from the residence at that point in time. Now, she may ultimately have to move out, which is something that we might advise her to do and work with her to figure out doing, but she would not be rendered sort of homeless within 3 days, like the offender might want. And this is particularly important in terms of COVID, because as we know, many of you who were providing shelter services were shut down during COVID. I think actually one of the homeless shelters right now is on lockdown in Albuquerque because of COVID. And we don't want victims having to go into shelter, even though you guys all do a great job in your shelters. We don't want victims going into those congregate settings. We also don't necessarily want victims couch surfing. We want kiddos to be able to have this, even more so during COVID, we want the kiddos to be able to have the stability and safety of staying in their home. So I think that the word of advice here is that if you are dealing with a domestic violence victim who is telling you that she's concerned that her landlord is going to evict her and she's not sure about getting a domestic violence order of protection under New Mexico law, that is the best way to prevent eviction for herself. Any questions on those? And I'm hoping, Teresa, that we're monitoring the chats because I can't see it.
Yes, we're good.
Gwen, do you have a question or did you want to say something?
No, I just brought her on. Gwen is our policy director for the coalition.
Great. Hi, Gwen.
Hi, Edna.
Okay. So early termination of lease to flee domestic violence. One of the things that our housing attorneys will do is they will and can negotiate with landlords to allow victims of domestic violence to break a lease and be released from a lease without being subject to early termination fees. So a lot of, particularly the larger complexes, build in early termination fees, which can be, as much at, like, this is the idea of like forfeiting your damage deposit and your last month's rent that you paid when you first leased the apartment. And we will negotiate those types of things so that victims are not continuing to be liable for rent and other penalties. And the thing is that even if a victim flees an apartment, the landlord can still seek to have a judgment on those fees. And if it's reduced to a judgment or reported to a credit reporting agency, it can make survivors, it can make it more difficult for them to get new housing subsequently. Interestingly enough, the city of Las Cruces allows a tenant who obtains a domestic violence order of protection to break a lease without penalty. So that's a Las Cruces code that is only in Las Cruces. So congrats to Las Cruces for pulling that off. So there are no yeah.
I'm sorry, I just wanted to insert something in there about the coalition is working on a bill with Senator Cedillo Lopez and Representatives Rubio and Romero on trying to get lease protections for survivors so that they can break their lease without these penalties. So we're working towards that.
Yeah, so what I was going to say next is that recently, twice, I believe, Senator Cedillo and others before her have tried to amend the landlord tenant laws to provide for these protections, but twice it has failed. So, I think that speaks to the power of the landlord lobby. And like the New Mexico, there's like a huge apartment association that's a huge lobbying. Gwen, you would probably know more specifically who have put up roadblocks to that. But for sure, landlords don't want these protections. And I can tell you that there's a slew of attorneys out there whose primary jobs are to represent landlords, and they are jerks. They don't give a damn. They do not care. So they are happy to evict victims, even in the most horrific of circumstances. The other thing that I want to say, going back to New Mexico law, let me just back up. So the interesting thing about the eviction defense in New Mexico is that the existence of domestic violence is an eviction defense that is given to tenants when there is an act of domestic violence that results in a notice of a substantial violation. So remember, I said there are two types of notices of violations of the lease agreement. Well, there's actually three, the non-payment one, but I'm not talking about that. There's a 3-day notice of substantial violation. And substantial violation means something resulting in significant injury to somebody, or, it's kind of like the really, really violent types of domestic violence incidents. And there are 7-day notices of violation. And that could be just kind of your standard. He pushed her, she fell down, cops came, they arrested him. Under New Mexico law, the defense of domestic violence only applies to 3-day notices of substantial violation. So technically, under the law, if your victim has been pushed, did not result in substantial injury to her, and she goes out and gets a domestic violence order of protection, technically the court, does not have to consider that at all as a defense. But for the most part, judges don't make those distinctions. For the most part, judges allow the defense, because it's within their discretion to do so, allow the defense to both a 3-day notice of substantial violation and a 7-day notice of violation. Okay. And our housing attorneys know how to make those arguments. So I just want to talk about our housing priorities. So we at Legal Aid, we are ramping up to deal with the landslide of evictions that we anticipate coming for non-payment of rent cases. And the Supreme Court has told us that they're expecting the stay to remain in place. So the stay of the execution of writs of restitution for non-payment of rent, they are expecting to keep that in place through the end of the year. But we know that we're gonna get a slew of them. And what Albuquerque is doing, so when a landlord, when the court grants a writ of restitution, the landlord has to literally go pick up a piece of paper that says writ of restitution on it, take that piece of paper to the sheriff's department. And every court is different in how they issue the writs. So for example, in Albuquerque, they issue the writ, but they don't print it out until the landlord requests that the court print it out. So that means that there's no chance that a landlord in Albuquerque is going to get a writ of restitution on non-payment of rent, take it over to the sheriff's office, and still try and get the sheriff to execute the writ, because they don't have the piece of paper. So the landlord in Albuquerque would have to go to the court upon the expiration of the stay and say, I have 10 writs that the court has granted, and I need all 10 of those writs issued in paper form, and then drive those papers over to the sheriff's department and have those writs executed. Every jurisdiction is different. So some jurisdictions will print out the writ and give it to the landlord right then and there in court. And those are the situations where the landlords are still taking those writs, even in non-payment cases, and trying to get the sheriff's department to execute those writs. So one of the things that New Mexico Legal Aid is trying to do is trying to come up with a protocol through the New Mexico Supreme Court on how those writs are going to be issued in an organized, uniform way, so that we don't have thousands of writs all being issued on the same day, driven to the sheriff's department, given to the sheriff's department all across the state of New Mexico, and have sheriff's time dedicated to evicting all of these people in a short period of time. And we're trying to do that on a just as a matter of humanity. But then you add into it the Rent Help New Mexico situation, which is New Mexico has, I think, $175 million worth of rent help that we are trying to get distributed to people to help them pay for their back rent. And New Mexico Legal Aid is working with the Supreme Court to try and come up with some rules and guidance that would allow the magistrate and metropolitan court judges to say to a landlord, look, you need to do everything you can to actually try and get paid from your from your tenant. And that means cooperating with the Rent Help New Mexico application process. That means giving your tenant 2 weeks to apply. That means recognizing that when the tenant applies for Rent Help New Mexico, it might take 2 or 3 months to get those checks. We're actively working with the court to come up with rules that will not have this just mudslide of shit, pardon my French. I know we're being recorded and I'm streaming live, but if we can go an hour with me only saying one curse word, I think we're in good shape. But so we're New Mexico Legal Aid, our housing attorneys are working quite closely with the New Mexico Supreme Court to come up with a way to create additional protections, regardless of whether or not the tenants are domestic violence victims. Okay. So generally, our New Mexico Legal Aid housing priorities, regardless of whether the eviction is being sought for a violation of the lease agreement that is either an act committed by the tenant or for non-payment of rent, we have our own internal priorities. We try to prioritize subsidized housing because once you get a housing voucher, that is gold. And that is a huge, huge, huge tool for victims and poor people, poor women, poor children to lift themselves up out of poverty. So we prioritize subsidized housing, whether it's through a housing authority, Section 8 vouchers, some kind of public housing or like an apartment that gets a federal subsidy so that it's able to offer rent based on income, LITC, low income tax credit properties, etc. And concurrent with that, we look at whether or not a client has the ability to represent themselves. So the clients who are super intelligent, super organized, are very, know their facts, have everything put together, we would not prioritize them because we trust that we could give them advice and counsel and send them into court to represent themselves. We do elevate domestic violence related evictions, regardless of whether or not it's a subsidized housing case. So if it's a private tenant that is evicting a domestic violence victim, we will assist there. And we also prioritize mobile home park cases where the mobile home is actually owned, because that creates a whole nother slew of just in my opinion, like bleakness, because people are buying these just horrific mobile homes, and like up on these mobile home parks, like at 9,000 Zuni is one of the biggest mobile home parks. They're buying these just dilapidated mobile homes because they think it's home ownership, but these mobile homes can't be moved, for example, so they're screwed. So those are loosely our housing priorities. Are there any questions about our housing priorities? So housing resources, we, Legal Aid, along with all of our community partners across the state, are pushing Rent Help New Mexico applications. We are trying to gear up people to help other people fill them out. Like we're and I think everybody's doing that. Probably the coalition's doing that. Is that accurate? Yeah. And what's cool about Rent Help New Mexico is that the inability to pay rent does need to be tied to COVID, but how tied to COVID it needs to be is not clear. So I've had victims of domestic violence apply for Rent Help New Mexico where the opposing party who was supposed to be paying child support got laid off from his or her job because of COVID, and the victim is now unable to afford rent. Victims who are, I have a victim right now who I've had apply for Rent Help New Mexico where she was a stay-at-home mom of 4 kids. Dad beats her up. She gets the domestic violence order against dad. She is now the sole caregiver of these kids, but she cannot find a job because of COVID, because she has 3 kids that she's unable to place in daycare, because it's opening up a little bit. Daycare is not so much of a problem, but women, primary caregivers who are having to stay home to care for kids. This was particularly relevant when schools were shut down and in person and daycares were shut down. So how related to COVID it needs to be, there's not clear guidance on that. I would tell your clients to apply if there's any way that they can say that they are at a loss of income because of COVID, no matter how tenuous that connection is. Bernalillo County Emergency Needs for Tenants is a website. The Mortgage Finance Authority has a lot of links to different emergency shelter, and many of the local housing authorities are elevating placement for domestic violence victims who are facing homelessness because of COVID. So lots of, and I don't, you guys, I can't speak to the rapidity with which these victims are being placed into housing. Historically, Section 8 voucher waiting lists were years long. It used to be that you could only get elevated on a Section 8 voucher waiting list if you had a letter from the district attorney's office saying that you were cooperating in the prosecution of a domestic violence offender. There had to be all of these steps. So I don't know how successful these programs are currently, but they are new programs in response to COVID and domestic violence specifically. Does anybody have any experience with this that wants to kind of share their thoughts or experiences, or maybe tips or tricks or DIYs or hacks.
You know, as we wait for that, I do have a question in
Uh-huh.
chat or a statement, but it is also a question and something that, you know, I would also like to hear more about. Um, so Alexandra Taylor stated that she has been working with the client, and apparently the landlord has been refusing to accept the rental assistance from the FDA, and then has also filed for eviction. You know, there's obviously they're trying to offer support, but to no avail. So what would you suggest in that situation? Because I am also currently a landlord, but I would really appreciate, you know, that rental assistance where they also, you know, are not applying. But this is interesting that landlords can decline support.
Yes. So the rental assistance is coming from DFA.
Yes.
Okay. And the landlord, the client has secured the payment, and the landlord is refusing to accept it. So and the landlord has now filed for eviction for non-payment of rent, or for some other reason.
Yes, for non-payment of rent. And then she also stated that subsequently the FDA will not reissue the rental assistance since it's been denied, apparently, because they won't cancel the check.
Okay, so a couple different issues. First of all, I want you, Alexandria, to have the client call our domestic violence helpline, because we can route that client in to help her deal with the eviction. So let me address the eviction piece first. So we see a lot of landlords doing everything that they can to work around the non-payment of rent issue, because they know that if it says non-payment of rent, that there's this stay, right? But the courts, and so they're doing things like they on a month-to-month lease, they are terminating the lease. They're issuing a 30-day notice to terminate the lease, and then they are filing a writ of it's not a writ of restitution. It's the language is escaping me, but it's equivalent to a writ of restitution. They're saying this person has overstayed the lease. They are no longer a tenant. Oh, and by the way, they owe me $600. The courts have really gotten pretty good at saying, no, this is still an end run around a straight up non-payment of rent issue. And the courts have gotten pretty, and we have been getting a lot of really good rulings across the state saying that you, landlord, don't get to do an end run around the non-payment of rent stay by doing all of these sort of backdoor avenues to get victims, to get tenants evicted. So landlords are trying every which way to do the end run around that. But basically what our argument is, anytime you're asking for money, that is a non-payment of rent issue, and therefore the eviction stay, the writ of restitution execution stay, should be applicable to that landlord. So to the extent that that's what the landlord is doing, whether in this case, even if the client hadn't gotten the rent assistance, please have them call us. My understanding, and I don't know, I haven't read the rules super clearly or super in detail, but my understanding is that the landlord cannot deny the payment. Okay, so what does that mean if they deny the payment, right? How do you force somebody to take your money? I think that what the court would say is, no, the client is not going to be evicted. But practically, what does that mean? So my understanding is that the DFA was telling people that they could take that money and get a new apartment. That was my understanding, Alexandria, of what the DFA was doing. So if DFA is refusing to reissue the check, that's not a circumstance that I was aware of. And so what I'd like to do is I'm going to write that down, and I'm going to ask Tom, our housing attorney, what he thinks about that. And he's actually giving another housing presentation. Otherwise, I would yell at him to come into our meeting. But I'm going to ask him about that, what he would suggest doing. So DFA, sorry, go ahead.
And I would like to also add that it looks like the check goes to the landlord, not to the client. So
Yes, correct. Right. So, right. So my understanding was that if, and this may have been in circumstances where the landlord was, because the landlords are required to participate on their end when DFA, or like in circumstances when Bernalillo County was doing it, to convey certain information back to the DFA or whatever the agency is. And so it may be that if the landlord is ignoring the request by DFA, DFA would then issue the check to the tenant. I'm not sure the logistics of that. And it may be, I mean, it seems bizarre to me that the landlord would participate up to and including everything other than accepting the check. So I can't really comment on the specific case, Alexandria, but we're happy to talk to the tenant and see if we can figure out exactly what's going on. But I will certainly find out from Tom if he's heard of this, where the landlord refuses to accept the check and DFA refuses to reissue the check, and what the courts are doing with that. My instinct is that the court would tell the landlord, you have to take the check. Like you either take the check or you don't. And in either event, if you take the check, it's not appropriate to evict this person for non-payment because they've paid. And if you refuse to take the check, it's likewise not appropriate for you to not take the rent check. Because what that sounds like to me is that this landlord really just doesn't want that person there. And really, maybe I would imagine the tenant doesn't want to be there either. Maybe then we would negotiate a mutual lease rescission, because my guess is that the landlord is trying to evict the tenant for non-payment of rent. Then they're not accepting the payment, and then they're going to want to go in and ask for all of the other lease termination fees, late fees, all of the other slews that they're trying to get, rather than just $800, they're trying to get, $5,000 worth of a judgment against the victim. That's my guess, is they think they're somehow going to get, blood from a rock. So we would very much want to talk to that person, Alexandria. So let me, so Alexandria, have that person call the 877-974-3400 number. And we are routing victims of domestic violence, sexual assault, and stalking who have housing issues through that number. So the 833 legal help number is much more cumbersome to get through on, as well as applying online, which is why I put it in little teeny tiny print down here. Because we really, if they're a domestic violence, sexual assault, stalking victim, and they have a housing issue, we really want them calling the 877-974-3400 number. Have that person call today, Alexandria. Were there any other questions or comments, Teresa?
We have something on Facebook. They stated that they have tried to call housing authorities, and apparently it's been really hard to get a hold of them and returning the calls. Is that because of the influx?
I'm sure. I mean, I know that Bernalillo, I can't remember if it's Bernalillo County or Albuquerque Housing, but one of them has a domestic violence COVID special voucher program. I don't know that much about it because I haven't read the internal regs on it. And they are saying, don't call at all. You have to go down and apply at their kiosk. So I know that some of the bigger housing authorities, and I have a cuckoo clock, so my apologies. It's clucking the 12 clucks in the background here. In case anybody is wondering, it's 12 noon. Albuquerque, and I can't remember if it's Albuquerque or Bernalillo County because I was looking at both of them, but they are requiring people to go down and apply at the kiosks. So it might really just be better to go down, which is like, here we are, we're in a global pandemic and they're like, come on down. I'll refrain from any editorializing and my thoughts on that. Yeah, I really, I know people have sat on the phone with Department of Workforce Solution for hours to get through. So patience is a virtue. I don't have anybody's number that I can sneak to you to get you to them, to somebody who will answer the phone, other than to say, I'm really sorry, and I know it's draining when you only have a certain amount of phone minutes. Any other questions or thoughts or comments? We have until 12:30, right?
Yes, so we do have a Q&A session right after. So if there's any lingering questions for anybody that is watching on Facebook and or here on our webinar, if you're currently experiencing something, please let us know. I did see that Alexandria also shared a link, which I also added on to Facebook, that I think it's very informational to what is currently happening. So if you want to read up on that, please do so. Thank you, Alexandria. Alexandria is part of our sister coalition at the New Mexico Sexual Assault Programs. Thank you for all of your work for supporting survivors. We do have our, oh, go ahead.
I just want to say too that New Mexico Legal Aid did prepare a bench book. And for those of you that don't know what a bench book is, a bench book is basically a bunch of attorneys get together and interpret and think through all of the ways in which a judge might interact or see laws coming before them. And it's basically like a guide for dummies. It's a cliff notes of how to apply certain laws and such when you're hearing as the judge certain cases. Benches are what the judges sit on. We call that the bench. A judge is on the bench. And so bench books are notebooks literally that attorneys put together to give quick reference for judges. New Mexico Legal Aid did do a bench book for magistrate and district court judges on how to interpret the laws, both when the CDC moratorium was in place, the New Mexico Supreme Court stay, the CARES Act stuff. So, and I have to say that we've really had a lot of success at the district court level when magistrates are super confused or just not interpreting the laws in favor of tenants, right? This is a brief window in time when tenants do have more rights than usual, which has frankly pissed off a lot of landlords and has pissed off a lot of judges who are pro landlord. But we've had success in district court on these eviction cases, even when they don't involve domestic violence. And frankly, I think that any domestic violence case involving the violation of these rights during COVID would hopefully be met with even more sort of horror by district court judges. We are appealing them, right? Which, circling back to the original, my almost first statement, which is if your client is walking into court in magistrate or metropolitan court, they need to request a recording. I'm gonna stop screen sharing because I'm gonna track down the form for requesting a recording so that I can put it in. I now have access to the chat, so then I will put it in the chat. So are there any other, now I can see that, this is so weird, now I can see the chat box, it's so bizarre. So, but I'm gonna leave you, Teresa, to still telling me what's in there. So is there anything else in there?
No, there's just a lot of thank yous and introductions. So again, please feel free to please add any questions. We do have some time. I also did want to introduce our policy director, or director of policy for the New Mexico Coalition Against Domestic Violence. That also is helping, as she mentioned earlier, in trying to get that policy with Antoinette Cedillo Lopez going, but I think she has also a couple other announcements as well. Thank you for being
Thank
here.
you so much, Terry. And thank you, Edna. I am always guaranteed a few laughs when I attend your trainings, so I totally appreciate you.
Well, I
Um,
try to make horrible topics somewhat palatable, and I have a very dark sense of humor, which is mostly inappropriate, but I try to keep it in check for presentations.
Well, I appreciate that little bit that did come out. I just wanted to say that the Coalition Against Domestic Violence works very closely with another New Mexico legal aid program that is called Safe to Be You. And Safe to Be You has legal services, civil legal services across the state of New Mexico for survivors who are LGBTQ plus. So that is something that you can call on anywhere in the state, and we'll try to figure out how to work with that client. So thank you.
Thank you so much. And it looks like, Deborah, which contact info? Would you like the contact info for New Mexico Legal Aid, Gwen, or the Coalition? Safe to Be You. Yes.
So let me, you can,
Hold on.
they quickly and easily, they can access Safe to Be You through the domestic violence helpline number. And then we route it. We have so many different specialized projects within NMLA, and luckily we all work together quite closely, and so we are able to route everybody where they need to be. But let me give you, so I'm gonna put the telephone number in the chat box.
We also have, if you, I have to put this plug in here, guys, I'm sorry. But please follow us on social media, Facebook and Instagram, where we do have a post for Safe to Be You if you scroll through. And then Gwen also placed the information in the chat. I will be sharing that information as well on Facebook for those of you watching. If you're interested in attaining that information, thank you so much for sharing that.
And for some reason, I'm not able to get, I don't know why this form is not opening from.
What can also
So
be done is I can definitely share that link for you, because you should be able to, we have that open for our coalition webinars and trainings where you can add documents in.
oh, well, that's asking a lot of fancy pants, fanciness. What I will do is I will track down the form and I will email it to you, Teresa, if you don't mind sending it out.
That works. That absolutely works.
And the form that I'm talking about, and honestly, like it is on the NM Court's website, but for some reason it's not letting me download it. But basically all it is a demand for recording, and the client is asking the court to make sure that they record the proceeding, because then that way we have something that we can look to appeal. Even though the appeals to district court are brand new, we don't have to necessarily look at the record. It's always fun if the magistrate or metropolitan court did or said something so horrific, and then we can kind of highlight how awful they're being to victims or tenants, poor people in general, which they are horrible to poor people. So yeah. So anything else? I don't think I see anything else. Does anybody want to unmute and say anything? Looks like everybody's going to different meetings and such. I thank you guys so much for tolerating my lack of knowledge on housing stuff. And again, feel free to call me or email me if you have any other questions. And everybody, please stay safe out there. Don't get COVID. Don't stay safe. Do stay safe.
Right. Thank you so much, Edna, and thank you all for listening. As mentioned, this training is recorded. You can also catch it on Facebook just in case. I am going to be putting the link for the survey in the chat. Don't worry if you miss it. I would recommend clicking on it right away so you all can finish your survey and get your certificate right away. If you have any issues, please keep me posted. You all know where to get in contact with me at training@nmcadv.org. Once you complete it, as mentioned, you will get your certificate. I will also be sending you an email with that document that Edna would like to send you all with the survey link, just in case for those of you that might have logged off a little bit earlier. We don't want anybody to miss that information, and then also for them to obtain their certificate. We are also going to be uploading this training to YouTube. So if you have not yet subscribed to our YouTube channel, I would recommend to please do so. We do have our advocacy cafe sessions listed there. We did a restraining order training a couple of weeks ago with Gwen Cadis, our policy director, and Sheila Lewis. If you would like to take a look at that as well, it's also on our YouTube channel. And then we also did a training on COVID-19 with Dr. Nestor Sosa. It's also a very informational training. Please let us know how else we can support you and what other trainings we can do for you. But, oh, Edna did place something in the chat.
This is a link to the website, and it's a PDF. You're gonna download a demand for record of proceedings, and that's applicable. Even though this form is for Bernalillo County, that's for any magistrate court across the state. So I think there's just a general form related to magistrates on somewhere on the nmcourts.website.gov website, but this is for Metro.
Thank you.
Sorry to interrupt.
No, that's totally fine. That totally works. And with that being said, it is 12:14. Thank you for joining us for lunch. We hope you have a fantastic Tuesday. Please keep in tune with our listserv. If you have not registered yet, that is also on the survey. We do have a training on Friday in regards to raising awareness for Recovery Month, which September is also Recovery Awareness Month, where we will have Jeremy Light and talking about the Albuquerque Celebrates Recovery virtual event. So please join us for that. And we will see you all soon. Thank you so much for joining us today. You guys have a great day. Thank you.